Teresa,
Okay.
can you hear now? Raise your hand if you can hear it. All right.
I can, thank you.
Yep.
Great, thank you. All right, so our hearing process is similar to a court proceeding. So staff's going to present their report. The applicant will have an opportunity to present an overview and answer any questions that the board might have. We'll then go into public testimony. We'll hear testimony in support, then neutral, and then in opposition. Then the applicant will have a chance to provide a rebuttal if they so choose. After that, the public hearing will be closed to testimony, and then we will move into board deliberation toward a decision. Before we start, does anybody require any hearing assistance? Okay. With that, Ben, we'll turn it over to staff. Thank you.
Kyle Snyder, Bonner County Planning Staff. I'm going to be presenting Title 40 road vacation for Bloom Lake Road right-of-way. File number is VS0002-24. The applicant is seeking to vacate the Bloom Lake Road right-of-way, which is a 60-foot wide public right-of-way. Proposed vacation area is approximately 1.16 acres. On the left, you have the submitted site plan surveyed by Glahey, showing that what is to be proposed to be vacated, and then on the right side is just a quick GIS snapshot of what that road looks like. Agency comments. So comments were provided by Bonner County Road and Bridge, Northern Lights, and then we had a late comment come in from IDL. The following agencies replied with no comment, and that was TC Energy, PhD, Ponderay Sewer District, IDWR, and Idaho Department of Fish and Game. As of the date of the report, no public comments were received. To provide some quick site information, the area to be vacated is approximately 1.16 acres. It is approximately 60 feet wide and approximately 840 feet long, and there are no structures within the proposed vacation area. As far as your access, you're taking US 95 north, exiting onto Elmira Road, and then left onto Bloom Lake. There are no mapped bodies of water within the vacation area. As far as your flood hazard zone, it is located within SFHA Zone X, per the firm panel listed. Area does not contain any mapped wetlands, but it does have mapped slopes of 0 to 30%. The soil type of the vacated area is shown. As far as your services for that area, it is not within a fire district, and it is located within Lake Ponderay School District 84. So Idaho Code 40-203 governs the abandonment and vacation of county and highway district system highways and public right-of-ways. So the commissioners may by resolution declare their intention to abandon and vacate any highway or public right-of-way, or to reclassify a public highway as a public right-of-way, where doing so is in public interest. So staff has received comments from Bonner County Road and Bridge that opposes the proposed vacation of the portion of Bloom Lake Road. That full comment can be found in the staff report. 42032, no highway or public right-of-way or parts thereof shall be abandoned or vacated so as to leave any real property adjoining the highway or public right-of-way without access to an established highway or public right-of-way. Burden of proof shall be on the impacted property owner to establish this fact. From staff review, there are at least 9 properties beyond the Bloom Lake Road public right-of-way that use the right-of-way as access from the county-owned Elmira Road public right-of-way. If the proposed right-of-way is vacated, it's not clear that these properties would retain access without a recorded private easement in place. 42033 states in the event of abandonment and vacation, rights-of-way or easement shall be reserved for the continued use of existing sewer, gas, water, or similar pipelines or appurtenances or other underground facilities as defined in 55-2202, Idaho Code for ditches or canals and appurtenances, and for electrical, telephone, and similar lines and appurtenances. So staff response, vacation of this right-of-way will not extinguish any rights-of-way or easements for the continued use of existing sewer, gas, water, or similar pipelines and appurtenances, or other underground facilities as defined in section 55-2202. Any utilities located in the proposed vacation portion shall be granted easements by the applicant accordingly. And that is listed as a condition of approval. When a county or highway district is to consider the abandonment or vacation of any highway, public street, or public right-of-way that was accepted as part of a recorded platted subdivision, such abandonment shall be accomplished pursuant to the provisions of this section. So this section of state code is applicable to the proposed vacation request, as Bloom Lake Road is a public right-of-way that was accepted as part of the Kehoe Minor Subdivision plat, which was recorded in November 2009. When a county or highway district is to consider the abandonment or vacation of any highway, public street, or public right-of-way that was never improved or developed, such vacation or abandonment may be approved through the dedication of a new highway, public street, or public right-of-way without compensation as set forth in subsection shown. Per Road and Bridge's comment, the right-of-way has been developed and is in use by the public. This provision does not apply to this project, as no private right-of-way is proposed to be vacated. Finally, it appears this portion of Bloom Lake Road was dedicated to the public by the plat Kehoe Minor Subdivision in November 2009. The right-of-way per county records is privately maintained, and per Road and Bridge comments, this public right-of-way has been used by the public as part of a historical access corridor for public lands. Again, you can see Road and Bridge's full comment in the staff report. 42036, all other highways or public rights-of-way may be abandoned and vacated only upon a formal determination by the commissioners pursuant to this section that retaining the highway or public right-of-way for use by the public is not in the public interest. Such other highways or public rights-of-way may be validated or judicially determined at any time, notwithstanding any other provision of law, provided that any abandonment under this section shall be subject to and limited by the provisions of subsections 2 and 3. Again, per the Road and Bridge comment, vacating this portion of Bloom Lake Road appears to only be in the interest of adjoining property owners. Approval of this road vacation may leave real property adjoining the highway or public right-of-way without access to an established highway or public right-of-way, particularly those to the north of the proposed area to be vacated. Any questions for me?
Board have questions?
I have a question.
Yes.
So the map that was presented earlier didn't really zoom out very far past that. Does that road access public lands?
Based on, I think there was a late comment from Idaho Department of Lands. I believe you should have that in their file. I think they did point out that they have an easement for access to those public lands. And then I think Road and Bridge also pointed that out as well, that historically has been used as an access corridor for public lands.
Okay. I know there's a couple of lakes or something up there that's on public land.
Would you be able to pull up the GIS? And,
Let me see if I got it up here.
I believe we'll see that there's both federal and state land parcels north of the subject parcels.
While you're pulling that up, I know that we got a comment from Road and Bridge, but Northern Lights gave a comment as well that had some concerns with the road vacation that I think bears reading into the record. Because they said that they're not opposed to the vacation of the public right-of-way. However, Northern Lights often relies on these platted ROWs to extend electrical services to the platted lots and beyond. So they provided more than just a simple comment, so I think that's worth putting into the record.
Agreed.
Was there more to that email?
Sorry.
A little bit more, yeah.
There was, NLI currently does not have utilities or equipment in that portion of the right-of-way to be vacated, but if we were to extend power north, Lot 1, and those lots further north may lose the entitlement granted by the plat. This could prove to be problematic for those landowners and residents I think they meant they, but it says the desire an electrical service in the future. Thanks for allowing the opportunity to review and comment. Sincerely.
So was that a dead-end road, or is it come out.
It looks
someplace.
like it dead ends kind of, or at least we stop mapping it out. I think it goes into boundary county at that point.
Okay,
But, I mean, there is, I think these were IDL land. A few of these might be, some of these are private, but there are some IDL lands up there,
Yeah, I believe there's also
Whereas
a lot of
just some-
federal land.
just some government lands.
Thank you. Does the board have any additional questions?
no.
Thank you, Kyle. We'll turn it over to the applicant. Do we have a representative from the applicant present? Okay, you're welcome to come up to the podium, sir, and present any information you'd like.
Hello, I'm Earl Rose now, and I live on that road that we're talking about, and it's just the place that they're discussing getting rid of that easement is right at the beginning of Bloom Lake Road, and it comes to my property line. And I own that square piece of property, kind of with a corner taken out of it on that map there, as you see. So that road goes right to my property. It's 800-some feet of easement. And the reason why we want to get rid of that easement right there is to give back to Stan, my neighbor, who owns property right at the beginning of it, and Evan Hawkins, and I'm representing him. He's overseas right now working for the government. So there's been a lot of issues up there that we've had over the years since I've lived there for 18 years now, with people cutting through that property, my property especially, and causing a lot of problems, which I don't have time to tell you all about. It doesn't really matter, but it's been pretty bad. We've been victims. I'll just say it that way. We're tired of it. There's a Denick Lake up there that people like to go to and hang out and do what they do or whatever. And like I said, lots of problems. Lots of trash, lots of no-gooders, to be honest with you. Unfortunately, that's the way things are these days. Now with the traffic, with the four-wheelers and such too going through, and the fire danger that we've had. It's terrible. Lots of fires. And the Forest Timber Capital up there who's suffered from it, Stimson Lumber Company, it's one of them, that they had a fire up there that somebody started, because I don't know why, people don't think these days, some of them. It's terrible. I've never seen anything like it. It's gotten bad. And they don't seem to care. That's the money that's out of their pocket and everything else, people's property's getting vandalized, trees are getting stolen and ringed, and it's madness. It's like, I've never seen anything like it, to be honest with you. I don't know what to say about all of it. Is just the people who own that property at the beginning of the road. My property, there is no easement through it. And I try to tell people that too. They come flying through there at all hours of the night, pulling in my driveway, looking for a party. I'm like, there ain't no party here, mister. I'm sorry. I don't live like that. We live off grid. I choose to live off grid. I'll never pull power on my property, but that's beside the point. That's just me. You understand? And we just want to live in peace, and we're not getting that. And I should have the right as a property owner too to say who comes through my property, especially when they want to sue you for something, right? It's like, really? So anyhow, these folks come through the property, ripping through it, these side-by-sides nowadays. And I've asked them, please slow down. I don't want to bother the local county sheriff and whatnot, because they got a job to do that's real important right here. But we're off grid up in the woods, so everybody thinks there's no laws up there. They can just do what they want. And there's all kinds of partying and drinking and just things going on that shouldn't be, and they don't just leave me alone or my neighbors. We get the brunt of it. But I don't want to trouble the county and take away the resources from you folks here because we can't handle it. You know, I don't call the sheriff. I try to talk to these people, and usually they, you know, I get some pretty bad comments. I won't say what they are or how we get treated about it. We just want to live in peace and be left alone. Now, the people who want to go frequent Denick Lake, they can. I'm not stopping anybody from going up there. They got a right of way to go there through state land. They can hike, but nobody wants to hike anymore. They want the convenience of driving through my property or my neighbor's property to get there and raise holy living problems. I'll just say it's not good. And not all of them. There's good folks, you know, and those folks that come to me and talk with me, and we deal with them, and we trust them. They can come through my property. I let people come through that I know I can trust, that I know. But other than that, I don't have to let anybody go through there. It's in my deed, my property deed. And I told my neighbors that, and I was let them in, but they went against me, and then they got the prosecuting attorney involved, right? And he had to check everything out and make sure that it was okay for me to put a gate up. And I did gate my property because of all the shenanigans that are going on up there. You know, poachers, and there's just such a list. If I wrote down everything that happened to us, you guys would be amazed. And none of you guys would want any of that stuff. But like I said, as a young boy, there's been so many places I can't frequent anymore because it's been bought and played out. You know, and like I told another fellow, maybe you should have bought this property and see how it is for you. Put the shoes on the other foot for a change, you know, but no, they don't want to hear that. So Evan, my neighbor, Mr. Hawkes, which I know real well, I've had to chase people on his land off, tell them, look, you got to get off of here. This is private property. People shooting right there on the corner. They think it's a shooting range. They pull up there, it's in the woods, and they start blasting their guns and all kinds of stuff. So basically, the people who live there, and my neighbor, Mr. Pardine here, they want their property back. It's only 800 feet of easement, which doesn't do anything. I mean, for anybody else, they're not going to gain access through my property. I'll tell you that, unless I allow it. From here on out, I'm just tired of it. I don't want to bother the sheriff with the issues or none of my neighbors. We just want peace, like I said. That's what we're looking for. If they want to go to Bloom Lake or go any further, they can hike up there. They can cut a trail through the woods and go. I don't care. That's what I do. You know, anywhere I want to go, if I can go legally, you understand. But there's a lot of riffraff running around these days with these, especially with these side-by-sides. And litter, drug use, I can go on a lot of things up there. It's just a place to go and just do whatever they want. And they think they're free. There's no law up there, but there is. And the people need to be protected. We do. We want our protection and want to protect my home, my family. I've been ripped off. Like I said, I got it all right here. I got it on record with the police department. I never got no money back. They tried to burn my house down. They almost succeeded completely. The one I was building, you know, but I'm just saying, I don't wish that on anybody, especially any of my neighbors. I love my neighbors. I try to help them. I always help them. I'm the one who plows the mountain road down with my dump truck. I have been doing it since I lived there. You understand? And it's like, I don't know what to say, folks. You all make your decision no matter what I say. I mean, I'm just here hoping that Mr. Pardine gets his property, that 60 acres, or I'm sorry, acre and something, and it's a 60-foot easement, goes to my property line. It's a yes or no answer pretty much, and I know there's a lot of people sore about it. You know, like I said, when I was a boy, there's plenty of places I can't go anymore and visit because it's bought and played out. But I respect the people who own that land, I'll tell you that much. And that's rightfully so, you should. Everybody should respect each other. That's what we're supposed to be doing in the first place. I don't know, but I ain't got all the answers, folks. I'm just here to wrap this up because I'm really tired. I'll tell you right now, I'm tired. Tired of dealing with a lot of folks and And I feel for them, but doesn't seem like nobody really cares what I feel or my neighbors. They just want what they want. A lot of self-entitlement these days. That's what I notice. It's going everywhere. It's a lot of self-entitlement. But anyways, I ain't got much further to add. Unless y'all have a question for me, I'd be happy to try to answer it for you.
So we'll have to limit that to the board.
Okay, I don't know how it
Thank you.
works.
So if you'd stay there for a moment, please,
Yes,
we'll
sir.
see if the board does have any
Okay.
questions for you, please.
Certainly.
I'll ask you a question.
Yes, ma'am.
Do you have, so I understand the personal issue, but when it comes to the road vacation, do you have a comment as to how the board can make, what binds our board in determining road vacation? Do you have a comment about that aspect of it? I'm hearing that there's a lot of public going through that you guys have a frustration with. But when it comes to how the county determines whether or not to vacate, do you have a comment on that specifically?
Yes, ma'am, I do. I'm here to work with the county, 100%. For access, especially the state and for the Forest Service and everybody. And I've already worked that out with those folks. I've had them in my house and talked to them and signed paperwork that they can come through my property anytime they need to. I've never stopped them. They have a lock on my gate, which I authorize them to
I'm going to
have.
pull you back to my question, though. My question is, we're here about whether or not we will make a decision on this particular road. And I'm asking, do you have a comment or something specific to what you're asking us to do, why you want us to do it? Not just in terms of what guides our decision, not just the frustration of the public, but the statute that we have to review in order to make the determination that you're wanting us to make. Because I'm hearing you say that you're willing to work with other people, but you're asking this board to make a decision.
Well, the decision is just to give back the property to
Okay.
my neighbor and my other neighbor. That's all it is. I mean,
Okay.
I don't know what else you're asking me for, ma'am. I truly don't. I mean, I don't quite understand the question, I must say.
That's okay.
I'm sorry.
No, that's okay. Thank you. I just wanted to give an opportunity for that. Thank you.
Commissioner Ford, any questions?
I don't think I have any questions other than the fact I would just like to make a statement that I don't disagree with anything that you said.
Thank you.
So know that going forward.
Well, thank you, sir. I appreciate it.
On the other hand, there's always a but, right? There's two sides to this coin.
Yeah.
And this board is going to have to make a decision on what the proper thing to do is. My question, I guess, would be by vacating that section of the road, we would be shutting down and denying the public access to those public lands.
I don't see that, sir, to be honest with you, because there's ways to get through or around me through public land to get to the public land they want to get to if they want to visit it. And that's through hiking. Okay, there's no road access, true, other than that road that got put through there to Bloom Lake, which the owners of Bloom Lake, it's private. So people can't really go there except for on the north side of it. They can come down to it, part of it. But as far as just to go up there, I mean, they can hike up to Denick. And furthermore, Denick Lake is not accessible to drive to. You have to park your car or vehicle and walk through the woods to get there legally.
Sure.
But people are actually diverting and going around and cutting through on state land, which I don't get involved in a lot of stuff people do. I mind my own business. But when they're tearing stuff up and burning stuff down, that is my business. I'm a good steward of the lands up here. You know, I live right there. We're living off grid. I don't never plan on having power. I want to live off grid. You understand? So does the people who live around me, like Stan and my other neighbor. We don't particularly need power lines drug up to our place. Just saying. I mean, that'll probably never change for us. But I'm not trying to keep anybody from visiting the lake up there. They can. The only thing I'm saying is that they just need to learn how to hike put on a backpack and cut through the woods, like I've done many times, and I do that frequently where I live anyways. I don't understand the problem, other than the convenience of driving through my property or their property, and throwing out their garbage and everything else, like I said, those issues. And I don't want to call the sheriff every time I run into somebody having a problem with them, because I have to constantly listen. Parking on his property, and I have to chase, this is private, I tell them, and there's signs, but people don't read these days. A lot of them don't, some do. There's a lot of good folks, but I would have to say on the other side, there's a lot of shenanigans. And I thought it was bad living in town, but I tell you what, I get more drama up there where I live off grid than I ever had when I lived in town. And that's a fact, I'll tell you. So that's all I got to really say, sir.
Thank you.
But thank you. All right, thank you all. Is there any other questions you have for me?
I don't.
Okay, then I'll turn it over to you folks. All right.
All right, do we have anybody signed up for?
No.
Can I ask, make a comment? I think there might be more than one person that's signed on to this in this room. I can't tell. Where I know he's saying he's speaking for someone, but this file has multiple people. So do we want to make sure no one else that's part of the request that we vacate wants to speak, because only one person did?
Would you like to speak as one of the applicants?
Yes, I am. Yeah, I'm the applicant, and then the person he was representing is the
Right,
applicant.
the other one. Yeah, so you're welcome to come up to the
Okay, thank
podium
you.
and offer your comments.
Okay.
Please state your name.
My name is Stan Pardee, and I own a parcel that's just east of Bloom Lake, just north of Elmira, right there in the Y. Okay, so to clarify some things, the Northern Lights thing, the power is like 2.5 to 3 miles away from this parcel. It showing up tomorrow is probably not going to happen. It will probably be years, if ever, power's up there. Everybody up there is off grid. Okay, so that's one issue I want to clarify. The other issue I want to clarify is there is no public access to Bloom Lake and Denning Lake up Bloom Lake Road. As of right now, there is no public access. The only public access is from the Y on Elmira to the northern end of my property, where there's a gate, because the property goes, the road goes through Earl's property, and there's no easement. It goes through Eric's property, and there's no easement. And so the parcels up the road, it's all been worked out. They have keys to the gate. And so this easement was granted to my understanding is the easement was granted to the county back when the person that I bought my property from was planning on some kind of subdivision, and then he kind of bailed on that idea. And so it was like, we're doing this easement, but for a subdivision, and it didn't happen. So there's no public interest in maintaining this easement, because all they do is drive from the Y to the gate, stop, turn around, and drive away. That's all they do right now, and that's not going to change whether this easement gets removed. If the easement gets removed, then we can put the gate at the Y, and people don't drive back there, stop at the gate, turn around, and drive out. So that's the situation as it stands, and I'm not sure if that was really clear going in, because the road, some people are saying, well, this is going to cut off access for the public. No, it doesn't. There is no access to the public, and there's not going to be access to the public, regardless of which way this goes, because there is no easement up that road. So it just kind of behooves us to have the gate out at the Y, so people can just drive back there, turn around and drive out, and it doesn't really affect the public, except save people from turning around.
Anything else you'd like the board to know?
Since we put the gate up, it's been a whole lot nicer up there, yeah. Because there was, like Earl had mentioned, people come flying down our road on their side-by-sides, 50 miles an hour. And, I realize that's a thing no matter where you go. If the roads are open, I dirt bike, and you go up Forest Service roads and you see all the donuts by the four-wheelers because they got nothing better to do, So, anyhow.
I have a question for you.
Okay.
You said that you put the gate up and you've seen a reduction of the problem. Does that, are the gates put up, there's a little bit of question as to, are the gates put up correctly? So Road and Bridge comment gives the question of when did they kind of go up, and are they
Okay, so-
on someone's property
Okay,
outside of an
So
easement?
to give you a little backstory, so what was that, about a year and a half ago? About a year and a half ago or so, my neighbor Earl had been dealing with the state and the feds as well, right, about gating the road. And he was unaware of this easement along my property line. And so at the Y, we put up 2 posts and a cable, and thinking all the details have been worked out. And then somebody up, not up Bloom Lake Road, but somebody up Elmira Road started digging, got a hold of somebody, prosecutor or whatever, started complaining, and then lo and behold, it was determined that there was an actual easement there that we were unaware of by the county. And at that point, that gate was taken down and moved to the north end of the easement, which is the property line between my property and Earl's at the northwest corner, and Evans and Earl's up there, right? And so that gate is in place. The state has a key to it, the feds have a key to it, and everybody up the road has a key to it, and it's legally installed. And because it's all, the survey was done, like we said, survey was done for, we've got several $100s into this deal. We had to pay for the survey to be done and all that. And there is no easement across Earl's property for this road. It's a private road.
So I heard you say that the gate is currently positioned legally across 2 property owners. And so you also said that the problem of public coming and going decreased when we put the gate up.
It did decrease, but they still come up to the gate and then
They
turn
come
around
up and
and
turn around.
turn around. And so they still, but it's like, I'm not sure I'm answering your question, but it's like, what's the point?
No,
You know,
well, that's what
okay.
I'm not asking the what's the point question. I'm saying that the problem that was described of what was happening has been mitigated with the placement of the gate appropriately. You're not going to get rid of all of it,
Right.
but a good amount of what the issue was mitigated when the gate was, from your statement, appropriately placed where it currently is right now.
That's correct.
And so the current issue is that people are essentially coming to a dead-end road and turning around.
Yeah.
And you're wanting a road vacation to be able to essentially move the gate farther down so that there's no turnaround traffic now.
Yes.
That's really what we're asking for.
Yes.
Okay, thank you for clarifying that.
And my point would be that that easement serves the county nothing.
Okay, thank you.
Commissioner Corn, any questions?
I don't.
Commissioner Williams, any additional?
No, thank you.
I do have a question, sir.
Okay.
You and the other representative have noted that it's your position that there are no easements for the properties north of where the county easement ends. Do you know, have you or the other applicant submitted any warranty deed or other information about the property? I didn't see anything in the application in the file that substantiates those claims about access.
You're kind of talking over my head here.
Let me ask staff, does staff know if any information regarding easements has been included by the applicants?
It wasn't clear that there was information on access easements for
Okay.
It's my recollection that IDL had a non-exclusive easement through the private properties for the continuation of the road beyond
That's-
our portion of the public right of way.
That's Idaho, what?
Idaho Department of Lands.
Okay.
Thank you.
Okay.
Did you have anything else you'd like to say?
I don't think so.
Thank you.
Can I say that was Matt Mulder, Road and Bridge, for the record?
Okay, do we have anyone in the room who is in favor of the project who would like to speak?
Do we get to make a rebuttal or not?
Not until we get through public comment.
Okay,
Then we will.
okay.
Do we have anybody online who would like to speak in favor of the applicant? Okay, do we have anyone in the room who's neutral that would like to offer public comment? Do we have anyone online who's neutral that would like to offer public comment? Mr. Kramer?
Brandon Kramer for the record. I'm a Bonner County resident. I don't frequent that part of the county, but anytime a road vacation request comes up, I like to pay attention, and it is not clear from the application. I think, Mr. Domke, you kind of touched on this, whether the affected parcels would retain access or not. And I am not a title professional, but there are very easily findable non-exclusive public right-of-way easements to all of the parcels north of those which are stated within the application, some of which are privately held, some of which are owned by the federal government or the state government. And so I would encourage additional information to be sought or presented prior to promoting or accepting this vacation request.
Thank you. Do we have anyone else that would like to offer a neutral comment? Okay, do we have anyone in opposition to the application in the room who would like to speak? Do we have anyone online in opposition to the application? Mrs. Plant?
Shauna Plant, for the record. I just wanted to say that I am never for limiting access to public land, and that's what I'm bothered here by. I know I have public access that was on my property, and I could not gate it legally, so I'm confused how that could be. I know people can hike, but there's disabled hunters. I'm one of them, and I fish, and I just think that the disabled needs to be able to get there. It is public land, and nothing's more frustrating is being blocked in where public land can't be gotten to when there is access. Thank you.
Thank you. Do we have anyone else online in opposition that would like to speak? Okay. Seeing none, we're going to close the public comment portion. We'll go back to the applicant if they would like to offer a rebuttal to any of those comments that were raised. Yes, please come back to the podium. Not sure what I said the first time, but we're going to go with podium. I don't think podium's an official term, so.
Okay. So my rebuttal to the opposition stated is that this doesn't change public access. They don't have public access now, except for just to my property. That's it. So it doesn't, that opposition doesn't really have any validity because there is no public access because of the fact that it's a private road through the neighbor's property. That's it.
Thank you.
I have a question, if you don't mind.
I don't,
So I'm going to hold this map up because this is what is in question, correct?
correct.
There's 3 lots that this road affects, it looks like to me. Does any of this road touch public lands at all? That, in this section?
No.
It's just
No.
3 privately owned,
Yeah, it touches my property to the east, Evans, to the west, and then it goes up to Earl's and goes to Earl's property.
so if I was to drive up this easement right now and park at the gate and block it for you, because I'm that kind of guy, Not really.
We have.
I would be trespassing if I got out of my car and started walking towards the public lands.
Yes.
Is that a correct statement?
Correct.
Okay. I'm trying to be very clear, and I'm going to ask planning as well on Road and Bridge. I want to be absolutely clear that by changing this, if we decide to do so, would not affect the access to public lands because that access does not exist currently.
So that, Commissioner, is why I asked the question that I did earlier. We don't have anything on the record that proves that claim.
That there's no
That there's
easement going
no
through.
access across the other private parcels to the federal and state land. And we have in Idaho prescriptive easements. And so there's a whole question about the validity of access that I don't see anything in the file that tells me that the public doesn't have a right to go to the federal or state land from that county-owned right-of-way.
So we don't have
So can
anything showing that there's deeded access past this point.
Can I suggest that we allow the individual to have the questions and then we move towards deliberation, please?
Any additional questions?
No, I don't think so.
Yeah.
Other than the fact that if you know that do you have any information that there is, that the story that we're hearing right now is that there is no deeded access past this point?
Correct.
Do you have any proof showing that?
Just the plat of the property is really all. I don't have any written proof on me right now showing that. That's Earl's property, and so he should have proof there. And it's sort of, it seems sort of like proof from the fact that we have dealt with the state, and the state said, yeah, you can put the gate up, just give us a key. And the feds said, yeah, you can put a gate up, just give us a key. And my understanding is that it was open in the past because the person who previously owned the Bloom Lake kind of recreational private land there on Bloom Lake had like tenants that would come and go. And he didn't want a gate and have his tenants deal with, well, that property's changed hands. The new owner's like, yeah, we can do a gate, no big deal. And so I believe that Earl has done his due diligence to determine that there is no easement through his property, but he just left it open because of the people up the road didn't want the gate. Well, now everybody up the road has said, yeah, we want a gate, and the state has said, yeah, we're good with a gate, and Fed said, yeah, we're good with a gate, so we gated it. That's my understanding, but I have no proof.
Thank you.
Okay.
So we have actually.
If you'd like to be, if you have evidence or would like to offer rebuttal, as applicants, you're welcome to be part of the rebuttal. Yep, it's part of your rebuttal time still. If you have evidence or information you'd like to offer with your rebuttal, you're.
Can I hand it to you? So you
Yes.
can actually- So I'm Earl's wife.
I don't have.
Can you say who you are?
I'm Barb Rosner.
Thank you.
Yeah, so we have it in our deed actually that our road is private from our property line up. And like Earl said earlier, I'm not gonna stretch that out. We had a lot of issues getting there. So the three properties were the Stans and Evans. So there's a lot of vandalism going on. And like Earl started mentioning, people driving up shooting grouse, and they're shooting towards the structures. So there is kind of hazard thing going on as well. Right now, we have a lot of people just coming up to our property line and then turning around in Stan's property, and there's littering going on. So after a while, the property owners are getting a little tired of it. But it is written in our deed that our road is private. And there's another access road actually from Elmira Road, if you drive a little further up, driving up to Sand Lake, there is access. If you hike it up, as Earl mentioned, you can hike up to Denick Lake. And I think that's the main lake everybody's asking about to have access to. And that Denick Lake from Elmira or Bloom Lake Road is actually Kelly humped by the state, I believe. Is it state or land of department? I don't know. They actually put a big Kelly hump in because there was too much negative activity going on. That's all I got.
Does the
Any
board have
questions
any
for me?
questions?
I got something to add.
Okay.
Okay. As we were talking about,
You have to state your name again, please.
my name is Earl Rosenau, for the record, okay? Middle name William, all right. So, one more time, we are all in agreement, the folks that live on our road, up there about the gate thing, you know? And I talked with the Forest Service. They came to my house and we talked about this before I put a gate at the beginning of Bloom Lake Road. And they said, please, we'd love you to do that because of all the problems they're having with the timber capital up there and whatnot and everything that's going on with the vandalism and the stealing and thieving and all the stuff, poaching, you name it. And the law's so far away, they can't come up there. If I call the law, because Bloom Lake got broke into so many times, they don't get up there by the time they get up there, the people are gone. They stole everything and whatnot, okay? So we kind of try to take care, but I can't always watch everything neither, you know? So anyhow, they said gate it, and we did. We thought we were in the right, and we checked it. They knew that there was no deeded access going up there to Bloom Lake. And there's the state gates all up in there. There's state gates. But as you go past the main road, past Bloom Lake, just a little further, you can get access to the state land and cut through the woods right there to get to Denick Lake. It's past my road, you understand? Or our road, which I should say. So that's the difference of that. And I mean, I think that's my deed. I didn't check my wife. She was looking. I didn't have my glasses on. But anyways, like I said, they got the prosecuting attorney. It went back over 50 years, I believe it was, to check for all that. They had stopped us from putting a gate at Bloom Lake Road, which no problem. They showed me paperwork. That's all I wanted to see. I thought I was in the right. I didn't do anything wrong, not trying to hurt anybody or anything. I thought I was okay what I did, you know. I thought it was the right thing to do, but apparently it wasn't, and it upset a lot of people more than I thought it was going to. It's not my intention, you know. I don't know, but anyways, I just wanted to clear that up. There is other access to get up to Denick Lake. That's my point. And even if you're handicapped, you know, I don't know. There's a lot easier places to go than that anyways. I don't know. I'm not trying to say, but.
So we've been given 2 documents that were numbered for part of the file. If we're going to use these, they need to be numbered and scanned into the record.
Can I make sure that's my deed for the house I live in now, is it?
Yes, if we can make copies of them.
And then we'll, yeah.
Because,
And they're, yes, so please, if you could verify and then,
yes, this is the one.
and then it's
You
noted.
can copy that. You can surely take that if you want.
Yeah, I'd like to have them entered into the record.
That'd be fine, sir.
And then
yeah,
within the title report, if that's also correct, there are 2.
Yes, this is it.
Thank you.
You can copy all that if you wish.
Nate went to grab him to make
Perfect.
copies.
Yeah,
On page 5 of 9.
So do you want to let him actually do it by
Well, I
deliberation?
think, but I'd like to ask if he has additional information. So
and I may have some other stuff in my folder that,
that's why I'd like to ask you, sir. So it talks about a right-of-way easement, and it has the instrument listed in items 8 and 9.
yeah,
And so if you happen to have those
I don't know if I do, but
easement documents with you,
I
that would
may.
help clarify the question we've been asking.
I can, here, you hold on to that, you want a copy of it?
Thank you.
So Veronica, can you make copies for,
Let me
Thank you.
check my folder real quick.
Yeah, if you happen to have any of the deed information with you,
he's not sure, but
we're gonna check and see.
Arson report that they tried to burn my place down and everything broken. I don't know if you need that, you need a copy of that?
No, sir.
Just the legal stuff.
The money back to
I can understand, but yeah, we're just trying to get clarification as to, like we said,
I did.
we're bound to work with the facts before us to make a decision, and I'm trying to get all the facts on the table
I
possible.
understand. Because I think 8 and 9 was for the state, the easement for them, and from what I understand.
That's what it appeared to be.
And for
We just don't know
federal
we just don't know the details of what that
Right.
allows.
I'm sure, I don't actually. But Roads and Bridges contacted me about 3 weeks after they did their
I don't think
investigation
he doesn't have another one.
with,
so we can copy those.
with the county and everything, and they told me that I could put the gate, they gave me permission to have my property. That was okay, so far. And I did.
So the documents you provided
I
are the
don't
ones
have
you
that.
have available at this
No,
time?
sir, I-
Okay.
I don't,
So Veronica's going to make copies of those for the record, and then we'll get the originals returned to you
thank you.
here shortly. Thank you. All right. So now that the applicants have had the rebuttal period, we'll move into board deliberation.
I would like to ask the question, and I hate to put Nate on the spot too, but I'd like him just to review that when it comes back out to get his opinion. And I'd also, like I said earlier, I'd like to get the opinion of Road and Bridge and planning if they have any proof. What I'm trying to find out is there an easement through that property, which I find hard to believe there isn't. But I would like to know that for a fact, because without knowing that for a fact, I can't make a decision.
I think that planning addresses that in a comment when they say that the section, when they're talking about the subdivision, they say that this section of the state code is applicable to the proposed vacation request. The portion of Bloom Lake Road that is requested for vacation is a public right-of-way that was accepted as part of the Kehoe Minor subdivision plat recorded in November of 2009. And so they're identifying that there is a public right-of-way that was recorded in that subdivision.
But I think it may stop where the gate is now. I think the subdivision is lots 1, 2, and 3.
Well, I'm saying the way that they word it, they're saying that it's applicable for this road vacation request, though, because they're specifically saying that this section of the code is applicable because of the portion that is being requested for vacation is a public right-of-way. That's how they worded it in their sentence. So they're saying that it's a public right-of-way that is being requested for vacation that was recorded in this subdivision request.
Yes, and I think the question being asked is about the adjoining properties to the north of the subdivision.
Yes.
And that's where Idaho Code 40-203, it binds us to be sure that we're not restricting access to parcels that are further beyond if that easement was to be abandoned. And so not only do we have the question about whether or not existing public access is in place, But then we have the question about if the easement is the only public access past the first 3 lots, then we don't have any evidence of there being any other easement that would allow legal access to those 9 adjoining properties to the north. So that's the Idaho code issue that I'm seeing per the staff report. So if you'd like to call on Road and Bridge or anyone
Yeah.
else to answer any of your questions, then why don't we do that before we continue with deliberation?
Because if there's not an easement past this, then this literally is affecting these 3 lots.
I think we're saying 2 different things, though. Easement, because the lots above it can have easements on the road itself. This question, I think we have to make sure we're careful on how you're asking it, because this is public right-of-way is what, that's what I thought you were
Yeah,
asking, was the
public,
public
yes.
right-of-way. But in a development, the individual parcels can have easements, which is not the same question
Yes.
that's being asked. And so,
Thank you.
so when you are originally what kind of this back and forth discussion is does the public have a right to this area? Because, which is a different question than, is there easement for the property above to use this road? And so that's why I was saying the public, because part of the question that was asked of the gentleman before he left was, the public doesn't have access, do they have access? But that's why I was saying, this document says that they do have, there is public right-of-way. And so you're wanting someone to confirm that there's access on this road for the properties above it?
I want to clarify that there's public access past this point that's being asked of us to vacate. Up to this point, there's public access. Is there public access past that point? That would be my question.
And I don't have a solid answer. Matt Mulder, staff engineer for the Road and Bridge Department. I have not been able to find a definitive document to show that there is public access. Though the most interesting document is that IDL has the non-exclusive easement. My understanding of easement law is that if it's non-exclusive, you can extend that right to other parties as well. So IDL has the ability to extend that access right to other parties. Does that include to the public? That I'm not sure. Maybe that's a question for Nate. I don't know if he would know or not, but that is an argument somebody potentially could be trying to make. And the public has notoriously used that road for a long time. I myself have been in there and camped at Dennick Lake on multiple occasions. And while there's not a prescriptive right because the county hasn't been maintaining that road, has IDL put in any maintenance money into that road? Has the Forest Service put in any maintenance monies to that road? If so, along with the public use for more than a period of 5 years, that could constitute prescriptive access for the public as well.
So let me ask you a question in a different angle. Have you found any evidence that there is not public access? Have you seen anything that would lead you to believe that it's a private road with no public access?
It's one of those things where you can't prove a negative.
I have to ask.
Oftentimes, you'll come across a private easement that overlaps public access or even dedicated public right-of-ways where multiple documents over the years were recorded that, or over the same piece of ground where somebody didn't know there was a public right-of-way and dedicated a new private easement on top of that. That happens pretty frequently. So just finding a private easement document wouldn't disprove public access either.
Thank you.
Commissioner, would you like to call on legal counsel to see if they're able to
Is
answer the
legal
question?
counsel up to speed? Nothing like being thrown on the spot, right?
Hot seat.
Nate Adams from the Bonner County Prosecutor's Office. I don't have all of the facts, but I can certainly give you some guidance in this. First of all, the applicants have talked about alternate access to the public lands that doesn't use their road at all. If that is the case, and if the board finds that that is the case, that helps applicants request to extinguish or to vacate the easement. Whether or not it's easier to go through their property versus the other one, that is not, I don't think, part of the issue. The fact is, there are alternate access points to the public lands that helps their case. Does that definitively help their case? No, but that is a benefit in their view. Secondly, as far as the easement, it's good that you guys are asking about whether or not there actually is an easement, whether the gate that is there is appropriate or not. We don't know. That appears to be an unknown. I don't have that information. If there is easements through the applicant's property, through this gentleman's property onto the public lands, that would go against, obviously, the applicants, because now you've got easements all the way to the public, the public access to public lands. That would go against the applicants, certainly. What the other gentleman said, and I apologize, I don't have their names right in front of me. He said that the homeowner or the property owner before him was going to subplat the property and sell it out. That's where that easement came from. If that's where that easement came from, it would make sense that there would be no further easements past his property, since nobody else had gone through that platting process. And so if that easement is there and ends at his property, that would be a logical explanation as to why there are no further easements past his property, because they didn't go through that platting process, and so that easement would not have been there. So I'm giving you all this information to help you inform your decision-making process. I don't have any of the answers as to whether or not that is the case, but these are legal issues that you can consider. And so whatever the board finds is there, but those are pluses and minuses for both sides on this, depending on the facts that you find.
The subdivision was approved, that didn't get followed through it. But the approval of the subdivision with the condition, it still exists even though they didn't move forward with it, correct?
That's what it appears. It appears the easement.
And so if someone were to pick up the ball and wanted to do something differently later, that those conditions, because the conditions stay with the land. It doesn't remove because they didn't move forward with it. And this is a planning one, because we've had this happen before where it moves with the land. And so this piece of land, the Kehoe Minor subdivision, has a public right-of-way that it would be impacted by this road vacation. Alex? Because let me say it probably more simply. If this road is vacated, the vacation removes the public right-of-way.
That would be correct. So as far as I can tell, the subdivision was completed in 2009. And that's what created lots 1, 2, and 3, and dedicated that portion that we're speaking about today to the public and became public right away. So the county does own that portion of it. That is how it was created, and now that is that's what we're talking about now. There wouldn't be the landowner wouldn't have the right to dedicate the rest of the road to the public unless they own that road prior, or own the land prior. But it's just the portion that they own, or that they owned at the time they subdivided. They had the right to make that a public right of way.
And this was deemed a condition of approval of the subdivision?
That's a great question.
Because
I have
I
not
thought
looked
it-
into the subdivision itself,
I
but it
thought
was
that-
dedicated dedicated to the plat, and that does make it a binding public right of way. Unless otherwise vacated like we're going through today.
So I'm looking for some kind of documentation or proof to show that that road, Bloom Lake Road, was never a public right-of-way. And then when this subdivision was created, it was going through this one person's property, and they deeded that as a public right-of-way. But we don't have any paperwork or proof to show that, I bet.
I will do some quick research to see if I can find the file that created this subdivision.
Because essentially,
files?
this is if you look at it from a point of just land, the land is there, a subdivision is created, that then creates a public right-of-way. And so we are today saying, let's remove the public right-of-way. But the public right-of-way was created, whether or not there was an access before or not, the subdivision creates it. And the subdivision gives the public the right to access, even if it doesn't make sense as to how we got there. The public has access because of this subdivision, whether it was a conditional approval of the subdivision or just the way they built the subdivision. So removing it, even if the idea that we can shift the access from this, it's not about shifting, it's whether to remove the access or not to remove it.
That's correct.
It's not about a shift.
No, it would not change. So part of Title 40, sorry, I didn't say my name, Alex Van, Interim Planning Director. Part of Title 40 and part of the conditions of the vacation, should the board choose to approve it, would be that no lots or parcels beyond that point be left without access to their property. So it would have to be dedicated as an easement for the remainder of the properties, for those properties to be able to still have access, but it would not be open to the public unless otherwise stated in the Department of Lands easement, if the Department of Lands decided to
And Title
grant
40
access.
additionally tells us that the vacation must be in the public best interest, that we need to show that.
That's correct.
Thank you.
Can I ask you to throw that map back up there for me, please, Alex, and show where the public lands are in regards to Bloom Lake Road?
Question, actually. So,
I might have to call Kyle up for that. I'm not super familiar with the area, so he's more familiar than I am.
go to the north border of the county on 95 and then head east a few miles and find it.
So you have Bloom Lake Road, which is this white line going through. There's some federal land.
Can you throw the layers on that shows the state and federal land force, please?
Do we have that?
This is Bloom Lake Road here. Okay. So the portions highlighted in blue are owned by either the Department of Lands or by the U.S. Forest Service or by the federal government. There are certain different types of ownerships, but the type of ownership and the type of land trust that they put the land into, but nonetheless, it is still owned by the state or by the federal government.
So Alex, could you please zoom in here? Where it appears that the government land crosses Elmira Road? I think that's Elmira Road. Yes.
Yep. So it looks like this is IDL endowment land.
So someone could hike from there
access.
north.
That's the access point I heard the applicant speaking of earlier.
Yes.
I'm going to throw our road layer on just so we're all seeing where we're going. So, and that portion is owned by the county as well.
So because the road turns white there where we're talking about, Are we saying we're fairly confident that there's no public right-of-way at that point? Where it transitions from yellow or gold to white?
We don't have documented deeded public right-of-way beyond that point. That much I can say.
Just maybe undocumented.
So I'd like to ask Nate a follow-up question.
You can just grab that microphone.
Yeah. So because the applicant at the board's request did have and provide a copy of their deed, the deed indicates two rights-of-way that have been granted on their parcel. And it has the instrument number of each listed.
Could you give me the
Yes,
page
sir.
number you're on?
It's page 5 of 9.
Okay.
It's at the title, it's Schedule B. And then if you go down to the bottom of the page, items 8 and 9, each list right-of-way easement or an access easement, and they have the instrument numbers listed. So would it be appropriate and acceptable for us to pull up those instrument numbers since the record now has those instrument numbers in them so that we can see the details of those easements?
You can. What is recorded here is that the easement is for specific corporations, it looks like. You got, on number 8, it is warranty deed between Pack River Properties, a Washington corporation, and George F. Gauza. I hope I pronounced that correctly. That was back in 1977. And then in number 9, it talks about Pack River Management Company and the state of Idaho, acting by the Board of Land Commissioners, an easement recorded May 5th, 1986.
Thank you. So then it would be acceptable because those instrument numbers are in the record for us to look up those instruments to see what they say.
I think so.
To include that in the record and for board deliberation.
I think so.
Can I ask for clarification on that? Because when we do the hearing, it's stated at the beginning that you have to bring your items marked if they're going to get entered in. Because this has happened before where it's not here when we're in the hearing. If we don't have to reset and have it to allow for it to come in a different way, because that's what we would actually be going to get the document that's missing for them from the county.
You're talking about
They don't
us going
have-
and finding it.
They don't have it.
They don't have it with them. My question is,
Can we just?
I know
pull it
it's
up?
available online right now. Can we just pull it up? and
I don't think in this
review it?
meeting you
Can't
can.
do that.
Okay, that's what I'm trying to clarify. Thank you.
Sorry.
Okay.
I didn't think you
Because
got
I-
what the way he was saying it was to pull it
Yeah.
in, so we have to.
I'm trying to.
We would have to go, you're talking about, we have to go find it and bring it
We
in.
would
Yeah.
have to bring
So
it in and.
I would like the board, because we now understand that there are easements granted on this parcel of land, which is the parcel immediately north of the current public access. So to me, that becomes, that's the bridge, right, to whether or not any public access legally exists beyond that. And so if we can answer that question, then I think as a board, we better understand how to respond to the checklist that state statute gives us. And I am seeing that we have 2 instrument numbers that were recorded with the county. So I would like the board to be able to review those easements to see what the language says, to understand whether or not we believe public access has been granted by either of those easements to help make the decision.
I don't think-
We can't create a record
Right.
to make a case for either side. It's what did they bring to us?
That is correct.
And so we're tiptoeing in the dangerous territory of
This
doing
is
that.
why I'm asking what our boundaries are, because I want to make the most informed decision we can
Sure.
within the law.
Right. Yeah, no, but Asia's correct, that they would have to bring that, they'd have to provide that. We couldn't go get evidence and then bring it into the hearing.
So to that end, my thought is that the board could offer to the applicants if they would like us to continue the hearing so that they could go and get those instruments, those copies of those deeds to bring forward so the board had additional information to consider before making a final decision, that we could extend that offer to those applicants.
I'm okay with
I'm trying to make sure,
I want to make the right decision.
we have a lot of statements, but we don't have all the facts to confirm the accuracy of statements that are being made, and we, on both sides of the argument.
Yep.
That's my,
On one hand, when I look at this, and if this is literally the only public access, I have no problem doing away with that POW. Because it only serves those three people, and all three property owners don't want it. I have no problem with that. My problem is, I am not 100% sure that there is not public access beyond that.
And I
If there
agree.
is public access or public right-of-way past that, I can't.
I agree with that
I cannot
conclusion.
block public access to public lands.
So that's the reason I'm bringing this up is I agree that those three parcels that currently have a public right-of-way associated with them, if that were to be abandoned and as a condition of that legal access easements were granted to the 9 parcels to the north, then that could comply with the statute requirement, and then the board would still have to find it's in the public interest. But I don't know whether or not we're creating a lack of public access to the north because of the lack of information. And again, I feel like we've heard arguments on both sides, and so I'm not clear on that. And I'd like to have all the possible facts available to make that decision if we can. So if the board's willing, if the applicant would like to do so, I'd like to continue the hearing so that they can bring forward that additional information.
I'm assuming Alex is going to provide some guidance here because it's a hearing.
Yep, and that's why I'm saying what I'd like to do, and then legal counsel can tell us what we're allowed to do. I've been told there are things I can't do that I want to do many times in my life.
All the time.
We're throwing all kinds of curveballs today.
And if we are allowed to do that, I would also like to ask the applicant if they could provide any documentation to show that there is no public access beyond that point, whether it be somewhere in their deed or something, and not just limit it to those two. I'd like to be 100%, not 99%. You know what I'm saying?
But the board is being asked a question about road vacation based on the rules that you're allowed to vacate. And there are two sides to every situation, and it's not for us to guide how do you achieve your outcome. We're in a hearing for them to present what we have. And so I just want to be careful of a path that gives someone a list of things to bring back to the board for review. Because that's what appeals are for. There's a winner and loser on every time you come in a case like this. So that's my cautionary concern, is giving a list of things you want, because equally, is this board going to say to those who oppose removing an access, give me a list of things that I would suggest you bring to support that position? I want to be as fair across decision-making, and that's my concern with the direction of either, because equally, whatever decision we make, it needs to be able to stand up. And I can't say, give me a list of things. If the board wants more time to deliberate and consider what has been brought forward, But we've had cases where we've been in the hearings, and you've seen this across years of always planning, where if they would have just brought this in their hearing, then we could have made a different decision, but we don't say, go back and get that and come back to the case, because there's two sides. So I want clear, I'll accept the legal, but that we're not, because it sounds like it's a shift to just tell one side what to bring back for clarification, but we usually are saying, this is the hearing that we're in to present the information, and we have the rule of, if you come in with a document for us to review, it has to be numbered for this hearing. Now we're going to potentially make a comment that says, go back and find these items, and this would allow me to make a decision differently. That's my concern.
Well, Alex Van Plain, interim plan director. So with my conversation with Nate just now, so the board can ask for additional information. If the applicants bring additional information, it would need to be made available to staff and to the public as well. And once that information is brought forth, public comment would be reopened, and there would be another chance for everybody to give comment on what was brought in.
It can give the way that we're talking about, it can give the appearance of saying, if you do this, then this is where I go. I just want to be careful, because we've had one where, I think it was a Panhandle Health one, where there was a document that we couldn't find, but each side said we knew that it existed, and what we did was we made a decision, and then it was appeal with the information based on the hearing. So I'm saying I just want to be careful with this idea of will help guide one side versus another, because there's another side that doesn't want an access to be removed, and we're not saying this would help me, because I could make the argument that one of the things Road and Bridge is saying is, you guys might be saying document or no document, but if you've been using this for over 5 years, then that is public access to it based on that prescriptive easement. It could be the case. We're not talking about that aspect of it, we're just going on one side of it. So I want to be fair and equitable to both sides, because whenever you're taking away public access, that's a big deal. Even if you can say, well, you can go a little bit farther down the road and you have access, it doesn't really matter. It's still public access that you are removing off of that, whatever it is that people go out there for. And so I want to be fair and equitable to both sides on the issue. So with understanding that if the board wants to say, bring back these documents, but I want to be fair to both sides, because a lot of people do use that and have been using that, which is why the group is here, is because the public is using it. They're not here because it's not being used. So I just want to be fair. That's my concern on removing any public access to something. And in a hearing, I understand wanting clarification of who had access and who didn't have access, but equally being fair of how we receive the information and guide one side versus another side. That's my comment on it.
I agree with you.
Yeah.
Sorry. I agree with you. I want to be fair with all parties. And depending on how this document comes back, if it even comes back, will help clarify, I think, the decision made. I don't think we're looking for ways to approve it, nor are we looking for ways to disprove it. We're looking for enough information that we can make an educated vote to vacate or not vacate. And like I said earlier, it doesn't make any sense to me to leave that public access if it literally goes 800 feet up the road and stops. So if there's a document showing that there is no public access beyond that, that helps make that decision. If there's a document that shows that there is public access past that, then I cannot in good conscience vacate that right away, knowing that there is a public access going past that. And what we decide is, if we decide to vacate that, now we have put a gate up between public right-of-way and public right-of-way with no access getting to that. So I don't look at this request as being impartial to one side or the other. I look at it as being information that is necessary to make the correct decision. I can go either way, but I want to make sure that there is or is not public access beyond that point.
I agree. My desire is to try to get as many of the facts as we can on the table based on the information that's been presented, because it's not conclusive at this time, in my opinion, the information that we've received. And so if we can do that, then I think it's fair and equitable to the applicants and the public, because then there'll be new information submitted into the record and the public has the chance to comment on that information. So we get to hear both sides again before coming to a decision. To me, that's the best case scenario, is to see if we actually have more pertinent information.
And I think the public would appreciate it too. I think the public would appreciate the fact that if we decided today to go ahead and vacate that because we believe there's no public access beyond that point, and then a year from now we find out there is, we're going to have some irate public out there because we didn't ask for this information, and vice versa. If it's proven and shown that there is no public access, by allowing this to continue is just creating a problem for the property owners. I really think it's in everybody's best interest to make sure that we get as much information as we can.
So we've all stated our thoughts on that. Just want to circle back to legal and say, could you please confirm that you believe that if the board were to choose to continue the hearing and allow the file to be open to accept additional information and public comment, that would be a legally acceptable approach?
I think it would be legally acceptable. What Commissioner Williams was saying would certainly be the cleanest. They have their shot. Today's their day. They submitted what they submit. And if you make the decision and you say, I don't have enough information to follow through the vacation, that would certainly be the cleanest way to do that. However, you do have the option of opening up. Now, does this favor one side or the other? I don't think it does. We don't know what the documents are going to say. The documents could go the applicant's way. The documents could go the other way. So I don't think that this favors one party or the other, since we don't know what the documents, if they even exist, would say. So this is just, you don't have enough information and you would like more information to make a decision. So is it allowable? I think it is allowable. And so I think you can do that. But what Commissioner's point is very well taken, that it would be cleaner if you say, based on what we have before us right now, we can or cannot make a decision and move forward from there.
Thank you. And so I see the two sides of the coin, and I agree from a process perspective, it would be cleaner to make a decision. And if the decision ends up being a denial, then the applicant has the right to appeal and bring forward additional information in an appeal if they find and choose to do so. At the same time, just given the way the conversation has played out and seeing that there seems to be additional information that could help make the decision, I would prefer to not have to see folks go through an appeal process if we can simply continue the hearing and see if we can get the additional information needed to make a well-informed decision. It really is a toss-up, but I think it's if we have the opportunity to prevent the need for an appeal, then it seems to me to be the course I'd prefer to take. While I realize it's perhaps not as simple, but in my mind, it's a preferable approach.
Is it not preferable to allow a decision made based on what they presented and that they appeal with the documents? And if they don't find the documents, then the decision stands, but they have a period? Because then you're opening up for a whole nother hearing with a whole nother process versus you've essentially gone through much of that. And so the current information you have enough information that tells you don't have enough information to justify the vacation. So there is enough information. It's that if you had the documents that you're identifying, you might be open to a different determination. But in this particular hearing, you don't have that information. So what, in terms of process, what is wrong with saying the current information presented doesn't allow me to vacate this road? However, you can appeal within this time frame with those documents, and then we can review solely on those documents and then address that. But then you don't have to necessarily put yourself in a position of opening up to a whole nother hearing, and then it accomplishes both. And there is a reason to have clean hearings because of litigation and what it costs to both sides, the applicant, the county, but then it allows for clear direction without having to do a full-on review of this file. That would be my recommendation on this, because with all cases in this, there's always going to be something someone's going to hear that could have been, if I brought that, I may have been able to sway. And so do we not make decisions, or do we make the decision based on the hearing as presented, and then people have the appeal process by which to say, and we do this all the time, you go into executive session and the board votes on, what do we want to hear in terms of this? So you could make a motion that said, based on the information, this is the decision. However, we'll allow an appeal with these documents within this time frame, and then if they don't make the time frame with the documents, then we don't have to come back and revisit the whole issue again. That would be my recommendation for the situation at hand.
I see your point. I think the advantage to that would be there's less potential inconsistency in the future.
Yeah.
When we run into this. I mean, I'll be honest, it's just there's half of me to say, and I don't want to make this more difficult on the applicants, but I think from your point, Commissioner Williams, from a process perspective, it would allow us to be the most consistent on each file going forward, that if we don't have enough information to make a clear decision, then it is incumbent on the applicant to try to provide all the information. And so the fact that we're finding deficiencies in that information is the responsibility of the applicant. So to put some onus back on them, I think is reasonable as we talk through all that. And I like being as consistent and clean as possible in our decisions. And so I see your point that you're raising with that. And they do have the right to appeal. So if they find documentation that they think makes their case stronger, then they could come forward with that through an appeal process. To your point. And I don't think we don't have to say it in the motion because it's written into the codes. So,
And then we don't have to address the continue to a date certain and hold time that may not produce the document.
True. Yeah, I think you've raised a very good argument.
Yeah, it's a two-sided coin. On one hand, I don't want to create a burden for the applicant, but on the other hand, I do understand that we should be able to make a clear-cut decision on the information that was presented to us today. And I do appreciate the fact that they can appeal if they do find that document, and we can review that, and we can either let it stand or we can change our decision at that time. So, and I do agree that procedurally, I'm thinking about it the whole time we're talking about this, and I'm like, well, this is setting a precedence that a year from now, we're going to have something and they're going to get upset because they want to present something that they didn't, and then it's going to be referred back to today.
Yeah, that's where I'm landing
I'd rather
too.
not go down that road either.
Yep, I agree. And that's the
So-
consistency piece, I think, that the approach that Commissioner Williams is suggesting does allow us to be the most consistent going forward with each additional file, like you're saying.
Yep.
So I think the best thing to do would be to walk through the different sections of the code and just state if we agree or disagree whether or not it's being met, so we can come to a conclusion. My suggestion would be, bless you, that we start on page 7 with the staff analysis that walks through Idaho code.
You guys talk so long, my computer died. I need to go.
Need a cable?
Well, that's a first.
We out-talked you?
Man, write this moment down in history. We out-talked her. Are we still on the record?
3-0 died.
I wasn't the talker this time, I was this other.
Hey, Brian,
Yes, sir.
hasn't died yet.
Battery's still good.
I'm still running, man.
But if the lights go out. Full restart.
You gotta go first, Ron, because I've got my, to reboot.
You have to charge up a couple minutes.
I just got one thing.
Okay, so if you want to start on page 7, I don't see a problem. So I think we're talking about down there at the second staff report. I don't know, I'm going to skip a little bit. I'm going to talk about the whole page if you don't mind, or would you rather go?
If you don't mind, if we go subsection by subsection, just to make sure we go through them all. So if we
Okay.
start at 40-2031, that would be my suggestion.
So as per Idaho Code 40-2031, I accept that and accept the staff report.
40-2031 was the I'm waiting for. my
Sets
load.
forth the procedures for the
Procedures,
hearing.
yes.
Just
Consideration of
procedures.
Yeah,
petition.
there you go.
Yeah, I'm sorry, I
It's
forgot you
still
couldn't see it.
loading.
I'll read it.
I concur.
As do I. Gonna go back and forth?
As per, no, I better go
You
because she's
gotta
still
go.
booting
It's
up.
still booting up.
As per Idaho Code 40-203 subsection 3, I think this is
We have
where,
2 still.
excuse me?
We just did subsection 1.
Yes, we're doing,
So now we're on 2.
I skipped 2.
You had a computer.
I could make it bigger so I could read it, huh? I would move to approve the staff report, and I see no issues with that one either.
So the staff report indicates that it's not clear that these properties, the ones to the north beyond the right-of-way, would retain access without a recorded private easement in place. So I agree with that, so that if it were to be approved, a condition of approval would have to include
Yes.
such recorded easement.
May I just get one more piece of information for you?
Yes, sir.
So, under Lupa, which was kind of, well, I know. There is an appeal back to the board. Under Title 40, where vacations come out of, Title 40, 203, what is this? 203-1K says, from any decision, a resident or property holder within the county or highway district system, including the state of Idaho, yada, 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 may appeal to the district court of the county in which the highway or public right-of-way is located pursuant to another section. So
Okay,
the
we're not
appeal
under
would go to the
Lupa.
district court. It would not come back to the county.
Yeah, because we're not under Lupa, we're just under Title 40.
We're under Title 40. So if they appeal it, it would go to the district court.
Gotcha.
They may, can I bring you back? Yep. It's a may appeal, they
May
don't
appeal.
have to appeal
Correct.
there.
Correct.
And so are you saying that we couldn't make a motion that allows them to bring it back to us? Because it's not a requirement, it allows them to bypass us if they don't like the decision.
I think what they would do, they could appeal to the district court, or they could just reapply for.
They could bring it back to us. It doesn't restrict them from bringing it back to us. What it allows them to do is say, we don't like the decision, we can go past you. That's what this does. It lets them pass us.
Sure.
It's not a shall, it doesn't push our decision doesn't push them to district court. It allows them a pathway to district court.
Right, but what I think that statute is saying is that there's no appeal to the board. The appeal goes to the district court.
The appeal goes to the district court.
There's no option for the board to appeal.
Because it would have to be in our code.
Where LUPA allows, because the board is the final decision maker, it allows them to reconsider their decision, but it's a completely separate statute where it gets argued before the court of whether or not it is in the public interest, or that's my opinion, but that's not a legal opinion.
It's not a shall in there. So when I made that suggestion, it was because I know that's in there, but I don't see why they couldn't be given a motion that allows them to bring it back to us to reverse our decision.
Because there's no mechanism in the statute to do that.
Even though it only says may and not a shall?
May means they may appeal. There's no requirement to appeal. So if they decide to appeal it, they may do so. To bring it back to the board, there is no statutory mechanism to bring it back to the board. So if you deny it, they can either appeal to the district court, or they may refile the request for a vacation.
So a new application.
A new
Would be
application.
the county path.
If you want to come back to this board, it would be a reapplying. It would not be an appeal.
Gotcha.
Any more wrenches to throw?
Which I guess a reapplication is not drastically different than an appeal in this case.
It is, because even in this one, it says that we're only accepting our information at our hearing. So I don't see a difference of saying come reapply it. I don't, so
Other than the fact, if they reapply, then we're going to hear the whole hearing again, and not just the.
True.
But that's
But
going
it
to be your
does-
situation anyhow, if you're going to say you're going to open it up so that they can hear more.
Yeah, we're kind of back to that regardless. And I think it does maintain our trying to be consistent with future files about making the decision on the information before us. And then to Commissioner Williams' earlier point, if I recall correctly, if they find proof that they think is in their favor, then they would likely reapply, which would make sense. If they don't, then the answer's already been made, decision's been provided, and they understand the board's position, so the decision would just stand at that
There's
point.
there's nothing preventing them from reapplying.
I don't believe so.
No,
Is there any time frame that could they reapply as soon as they wanted to?
whenever they wanted to, because a decision was
Okay.
made.
Which may even be beneficial on the applicant's part. They need that additional time.
Thank you for clarification.
So we were on
I think we just finished.
2033?
We just finished 2032, so I think we're ready to start 2033.
So I don't see anything in there that limits utility district such as Northern Lights 25 years from now, if they decide to want to pull power up there, that if this right-of-way is vacated, that they wouldn't still be allowed to do that with the consent of the property owners.
I used the note from Northern Lights to say that there's a, kind of exactly what they said, the possibility of the problem associated with doing that. Not that there could be a way, but there's a guaranteed way the way it is, and there's a potential problem if there's a change.
And the issue falls back again on whether or not there's a public right-of-way past this point, because if there isn't, all we're doing is affecting these three parcels again.
On this one, it brought into kind of the comment that either Road and Bridge or Planning made about what IDL can do with their land and how they can give easements, and it made me think that with the current situation, that there's a more of a guarantee with a question if we change it. So that's how I left that part.
And from my perspective, I have a little different way of looking at it than both of you. I see this being subsection 3 being specific to the continued use of existing utilities, and since we don't have existing utilities, I don't think it's applicable.
Yeah, I think I would probably agree with that statement.
It says Idaho Code 42033 sets forth the standards for reserving easements for utilities and other, and so that I took it as reserving for future, not just current.
It's just when you get into the additional language, it specifically says continued use of existing.
But it also sets forth standards for reserving easements, which to me is future. That's why I put that in there. So it's 2-1 on that one.
Yeah, I believe so.
Subsection 4. So addressing public right-of-way vacation.
For me, based on the current record, that the public has, that there's no information to say that the public does not have that access based on what we have right now.
I don't see that it's in conflict myself, and I would move to adopt the staff report.
So I agree. It's just stating that this is a documented right-of-way for the subdivision, so it's specific just to
Those
the
three
fact that it
lots.
is a documented public right-of-way currently.
And that's what I'm accepting.
Okay, then we're all in agreement. Subsection B focuses on that it has never been improved or developed.
I didn't find there's enough information on that one. Because there's too many players out there. I think Road and Bridge commented about whether or not IDL did anything or not.
And I see this as pertaining to just the area that's being suggested, the existing right-of-way for abandonment. And a road has been developed there, so I'd say there is a developed road per what the staff report indicates.
Can I ask the board a question real quick? I have a concern. Similar to one of the other cases that we had a few weeks ago. We can go through this and I probably agree on everything. But yet there still could be a denial that is not related to our worksheet, if you will. Because if the board chooses to, that we can't find enough information because of that underlying issue that we can't get past, are we going to run into a legal issue if we can check all the boxes and the board may still deny it?
So if we could check all the boxes and we deny it, I think we would have an issue. I don't think we're going to be able to check all the boxes because what we said previously in this hearing that we believe, I think I've heard all of us say that we believe there's a lack of information that proves or substantiates that there is no public access currently north of this existing right-of-way. And so short of that piece of evidence, I don't know how I can say that it's in the public interest because I don't know if I'm removing existing public access.
I think that if you were going through it just based on the conclusions of the staff report, that part makes it more clear. I think some of this, sometimes that question thing that you're going through can make it a little confusing. But when you look at the conclusions, I think it'll make it a little bit more clear.
Okay.
Like if,
Okay.
So I understand your point, but I think we're
Yeah, I
gonna,
just want-
I think we're going to reach. Yeah.
Make sure we're treading in the right direction.
And then subsection C, it's a question of whether it's a private right-of-way, but in this case, it was a public right-of-way.
Yeah, so
Yeah,
that's not really applicable.
so the staff, yeah, and that's what the staff report says. And I would agree with that. And And then 2035C1. Basically, has it already been abandoned due to lack of maintenance?
Has that been proven to the board?
It's based on the evidence of the comment provided by Road and Bridge is the information in the record.
Did I hear Road and Bridge say that they weren't clear whether or not maybe IDL may have done something to that road?
Yeah, I think we don't have, what I heard was we don't have clear evidence one way or the other for either the federal or the state entities. So I do think we have a lack of clarity on that one, is my opinion.
Yeah, I think I do too.
So I think we have evidence that there has been private maintenance because there's been ongoing access through the actual public easement. So I'd be comfortable saying that it's not been abandoned due to lack of use and maintenance for 3 or more years, because we have testimony that people are living there and utilizing the road.
So are you saying that there's a conflict?
I'm saying that this does not apply. I'm saying the road, per this section of code, the road has not been abandoned due to lack of use and maintenance. Because we have testimony from one of the landowners saying we use and maintain the road. I plow the road. So that's my position on it.
So do you want to go just to the conclusions or?
Yeah, so I'm reading, yeah,
Because
so.
I think you guys you're going line by line of the actual
We are.
staff
Yep,
report,
we have
so
one
we'll
left.
do the conclusions.
We're going through 2035C1. The right-of-way has been used by the public. But has not been maintained at the expense of the public in the last 3 years. I don't have the evidence to show that.
Okay.
Because I don't know that if IDL has done any maintenance on that road in the last 3 years. That was not presented to us.
I see your point. We don't have any evidence in the record to prove that.
To prove that.
Okay.
So that's why I find it in conflict with that code. Would that be?
Yes, I understand. It does not. Yep, I
It
hear
does
you.
not meet that. The abandonment definition
We
because
don't
of
know
that
if it's
code.
been abandoned from that perspective.
That's my thought.
I concur.
I don't disagree.
So then the last applicable section of Title 40 is 2036, which focuses on that if the right-of-way were to be abandoned, it's would it be in the public interest?
And that's where we can't say again. We don't have enough evidence showing that it would be in the public interest.
My answer is that I can't say the abandonment is within the public's best interest because the public uses that access. And it doesn't, at this time, we're trying to determine there's additional information that's wanting to come in to address that. But to say and I think it's inherent kind of in the question is to lose access, is it in their interest? In this case, there's no evidence to say that it is in the interest of the public to lose that access.
Yeah. And I think the key language in 40-2036 is the part that says, which is at the top of page 9, all other highways or public rights-of-way may be abandoned and vacated only upon a formal determination by the commissioners pursuant to this section that retaining the highway or public right-of-way for use by the public is not in the public interest.
Yeah.
So we have to determine it's not in the public's interest.
And that falls back on the fact that we don't know at this time whether or not there's public access past this point.
Correct. And so that's
it's
the
in
conclusion of the
conflict.
staff report is using the word may. And I think it's very appropriate because in this case, we don't have clear evidence one way or the other. And so for me, since I can't make a positive determination, then I can't approve the request to vacate.
I'd agree.
Would you like to go through the findings of fact to see if we agree with them?
What you could do is go through the motion and the conclusions.
I believe with the motion that we'd be adopting the findings of fact, so we want to confirm if we're in an agreement with them.
Can we just adopt the findings of fact as stated?
Yeah, if you don't have any exceptions to the findings of fact, then it would be adopted as part of the motion.
I don't have anything in there that I see as that I could argue.
Commissioner Williams, are you okay with the findings of fact?
I am ready for a motion.
Okay.
As I am.
All right, if someone would like to make a motion.
I'll make a motion to deny this petition, file number VS 0002-24, to vacate the Bloom Lake Road public right-of-way as identified in Appendix B of the staff report based upon the following conclusions. Conclusion 1, the proposal was reviewed for compliance and the vacation criteria and standards set forth at Idaho Code 40-203. Conclusion 2, Bonner County has received objections to the petition or application to vacate the described area. Conclusion 3, the abandonment of the public right-of-way is not in the public interest. Conclusion 4, the landowner or landowners abutting said right-of-way do have access to his, her, or their property. Well, we don't know, do we?
We don't. So
You have to change your words. You can say that. So that it's not a do or a do not.
On the landowner or landowners abutting said right-of-way
you could say may not.
may have access to his or her own property from some other public street, public right-of-way, or private road. Conclusion 5, by granting this petition for vacation of public right-of-way, real property adjoining the subject highway or public right-of-way will not be left without access to an established highway or public right-of-way.
Can I pause you on that because we're not granting the petition?
I would recommend, I think we're still at the may or may not.
Same as
We
before.
don't have confirmation.
I will reread conclusion 5.
Thank you.
By granting this petition for vacation of public right-of-way, real property adjoining the subject highway or public right-of-way may be left without access to an established highway or public right-of-way. The decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to adopt the findings of fact and conclusions of law as set forth in the staff report or as amended during this meeting, and direct the planning staff to draft written findings of fact and conclusions of law to reflect this motion and transmit to all interested parties. This action does not result in the taking of private property. The action that could be taken, if any, to obtain the vacation is to file a new petition with the planning department and meet the standards required by Idaho code, or number 2, pursue such remedies as may be applicable at Idaho Code Title 4, Chapter 2.
I second the motion.
And number 1 would be exactly what we discussed earlier, that they could, if they find paperwork, they could file a new petition.
Agreed. Any board deliberation? Hearing none, roll call vote, please.
Commissioner Warren,
Yes.
Commissioner Williams,
Yes.
Commissioner Elty,
Yes. Motion carries. So file VS 0002-24 has been denied. We will now move on to file VS 0003-25. Actually, before you,
Thank you.
You want to take a break, Commissioner?
Elisa,
Just need a little more.
would you
info.
like a 5-minute break?
No. Where do I get information? What do I gotta do to do that?
You need,
Can you, sir? Thank you for your time, I appreciate it.
have a good day.
Alex, could you do me a favor? Could you guys have that conversation in the hall? Thank you. Did Commissioner Williams indicate that she'd be right back?
I got no indication whatsoever, but her computer is here.
Yes,
So
I'm
I'm
guessing,
assuming.
I'm guessing she'll be back momentarily. So we'll,
You want to take
we're gonna pause for a moment.
Probably had to go eat lunch or something.
Tell you what, we will recess until 3:40. And we'll see if we're ready to pick back up at that time. So if you want to sit back down for a few minutes. It's up to you.
Thank you, Commissioner.
Stretch your legs.
I think like everybody else, I'll probably go to the restroom.
There's gonna be a rush, right? After you. We rescheduled.
Thank you.
We didn't know if you were coming back.
If you could, just in case a question comes up, it's really helpful.
You didn't clean up your petticoat.
I could hear. I'm
Oh,
not
you can
that
hear.
old. I can
Okay.
hear.
Just checking.
Making it an age issue.
Can hear
It's almost
through
as
the
if she's
walls.
going after a protected class or something.
He's definitely.
Recessed.
$5 million request. Different case. We were waiting, and of course they did it.
I don't know if you heard, we recessed until 3:40 just in case you needed a few more minutes.
Oh, no, I just needed him to start reading it.
I wasn't sure if you had to go call somebody or something.
Thanks.
So
Sorry. Been harping on Christian of, he needs to start demanding they give us this stuff. They had this since the beginning of October, we're at the end. And
yeah, that would be helpful to have it early.
it's a lot of money. This one should be a little faster.
And that lower driveway, my front driveway, but yeah, no problem. I was told that that one came up from the other side of this property, down by the trailer. I don't know if that's true, but I don't know.
Already?
Right. No trailer.
I failed to bring mine, there's the difference.
He was preserving his battery.
One comment on your shirt and you turn it.
Yours were plugged longer. My battery's at 50%. Okay.
Well, they gave me a used laptop.
Oh, I see.
That has a short battery.
Lisa, if you want to let us know when you're ready, we can pick back up. All right, it's 3:42 p.m. and we are coming out of recess. And we are starting with file VS 0003-25, and we'll begin by asking the board about any conflicts of interest.
Commissioner Corn has no conflicts.
Commissioner Williams has no conflicts.
Commissioner Domke has no conflicts. With that, we will turn it over to the planning department.
Good afternoon, Daniel Britt, planning staff for the record. Before we get started on this vacation, as you know, this slideshow, well, you don't know this part, but the slideshow is very similar to the previous one. Do you want me to go through all the code sections or just address staff's analysis?
I don't need the code sections, I don't think.
Neither do I.
Okay, thank you.
Staff analysis, please.
So we're here to discuss a portion of Fairview Boulevard to be vacated. File number is VS 0003-25. The applicant is seeking to vacate the southern 30-foot portion of Fairview Boulevard in Old Town, Idaho. The right-of-way is currently 60 feet wide. The proposed vacation area is approximately 0.4 acres. This is the site plan that was submitted by the applicant of the portion of the road that is being requested for the vacation. This is looking at the general area of the vacation. And this is more of a close-up portion of that outlined in red. And that is just the southern half.
So it's not currently a road.
It currently is mapped as a road, yes.
But the road isn't there.
The road is there. The highlighted section in red there
Yeah.
is just the southern portion of that road. So to give some clarity, the northern half is in the jurisdiction of Old Town, Idaho, in the city there. So Bonner County doesn't have any jurisdiction on the northern half of that. Is it split right down the middle as far as who has the right to weigh in on it? I guess it's possible. I do know that the city of Old Town is here today to speak on this file specifically. So
We clarify, just to make sure we're all on the same page. Are we speaking about the southern half of the right-of-way or the southern half of the physical paved road?
Well, the road is
Or
not
both.
paved.
Okay. of
So
the
we'll start
road.
there. There's a portion that is paved, which I
Okay.
won't get into. But this is the portion, this is the southern portion moving to the northeast that we were talking about this afternoon. This portion here, more or less, is in the city of Old Town in their jurisdiction. This is Bonner County's jurisdiction here.
Okay.
Okay?
So we only plow one direction.
Well, we don't even plow it.
More to come.
Stay tuned.
Okay.
Okay. Is that all?
That's interesting.
Okay, it is.
Thank you.
questions, apparently. Please continue.
Okay. The following agencies provided comment: Bonner County Road and Bridge Department and Idaho Department of Environmental Quality. The other following agencies replied with no comment: Idaho Department of Water Resources, Cooney Ponderay Sewer District, Idaho Department of Fish and Game. All are the agencies that were routed did not respond. As the date of the staff report, there were no public comments received on this request. So a little side information, the area to be vacated is approximately 0.4 acres. It is approximately 30 feet wide and is approximately 570 feet in length. A portion of a structure is within the proposed vacation area. That's part of why we're here today, is because of that structure. Access is Fairview Boulevard is east of South Meadowdale Avenue, which is east of South Slate Avenue and south of Highway 41 in Old Town, Idaho. So some environmental factors. There's no map bodies of water is within special flood hazard zone X per firm panel number 16017C0850. There currently is not any wetlands on the property. It does, however, have map slopes from 0 to 30% or greater. There are a couple different soil types on this road. One is all areas of prime farmland, and the other one is not prime farmland. Services to this road is West Bonner Ray Fire District and West Bonner County School District number 83. The proposal has been reviewed for conformance with the following, which is Idaho Code 40-203, abandonments of vacations of county and highway district systems or public right-of-ways. So skipping over the Idaho Code portion, as previously granted permission to do, staff received feedback from Bonner County Road and Bridge. Road and Bridge that is in support of the proposed vacation of the portion of Fairview Boulevard. There's a detailed comment from Road and Bridge in the staff report. Based on the materials submitted in this application, no real property joining this area to be vacated would be left without access to an established highway or public right-of-way. This portion of Fairview Boulevard has not been developed. Moving on, staff found that the vacation of this right-of-way will not extinguish any right-of-way or easements for the continued use of existing sewer, gas, water, or similar pipelines or appurtenances or other underground facilities as defined in section 55-2202 of Idaho Code, for ditches or canals and appurtenances, and for electrical, telephone, and similar lines and appurtenances. Any utilities located in the proposed vacated portion shall be granted an easement by the applicant accordingly. That is part of a condition of this vacation, and that's found in B2. Section of state code is applicable to the proposed vacation request. The portion of Fairview Boulevard that is requested for vacation is a public right-of-way accepted as part of a, quote, map of town of Cedar Park, Idaho, plat recorded March 17, 1908. Right-of-way of Fairview Boulevard appears to be partially developed with hard surface materials for approximately 200 feet on the western end of the road. Beyond that point, going northeast, the right-of-way appears to be a narrow strip of dirt that is being used for access by one structure that is addressed on East Valley Street and not Fairview Boulevard. The northern portion of the right-of-way appears to be within the boundaries of the city of Old Town, Idaho. Provisions does not apply to this project as no private right-of-way is proposed to be vacated. Fairview Boulevard was recorded on March 17, 1908 on map of town of Cedar Park, Idaho, which is found in Book 1, page 100 in Bonner County Records. Properties surrounding this request are privately owned. The portion being requested to be vacated is within the jurisdiction of Bonner County. The northern portion of the right-of-way is within the jurisdiction of the city of Old Town, Idaho. Right-of-way Fairview Boulevard appears to be partially developed with a hard surface materials for approximately 200 feet on the western end of the road. Beyond that point, going northeast, the right-of-way appears to be a narrow strip of dirt that is used for access for one structure that is addressed on East Valley Street and not on Fairview Boulevard. The northern portion of the right-of-way appears to be within the boundaries of the city of Old Town. Based on aerial imagery, it appears that the applicant has used Fairview Boulevard within the past 3 years. The only structure's address on the road belongs to the applicant. There's no evidence in the record indicating that Bonner County Road and Bridge Department has maintained the right-of-way. Fairview Boulevard was first dedicated in 1908. Unknown at this time is if the right-of-way was ever constructed to meet any standards. However, based on the imagery dated back to 2018, the right-of-way does not appear to be constructed to public or private road standards. This being the last slide for Idaho Code 40-2036, this falls back on the commissioners to make this determination, so there's no review by staff. That concludes my presentation. I can take any questions.
I don't have any questions on this one.
So it's a 60-foot wide easement, and we're being asked to abandon 30 feet of it.
Not an easement, it is a right-of-way that's dedicated back in 1908 on a plat.
Being that it was pre-1953, that makes it an easement.
Okay, I've just learned something new myself. Thank you,
thought
Mr.
so.
Mulder. That's why they're in the road business and we are not.
What about fire standards? That come into play at all, that the fire district requires more than a 30-foot easement? Do we know?
We do not know. They were routed for comment and did not receive a response from the fire district.
All right. I don't think I have anything else.
And I think you may have mentioned this before, but it's not clear to me. The current paved roadway that has been installed and maintained by the city of Old Town, not by Bonner County. Is that accurate to your knowledge?
I have no knowledge of how that small strip of blacktop was laid down.
How it was created?
Correct.
Do we know, but based on the evidence you have, we have no record of the county maintaining the county's portion, is that correct?
Correct. There's nothing in the record. The applicant or the applicant's rep may have some insight to that pavement, or possibly the city of Old Town, since they're here, so.
So then going back to that section of state statute, when it comes to abandonment through lack of maintenance, that's the position that.
Given that this is
county
not
does
part of the county's road maintenance, then it's left to the property owner to, I assume, maintain that road. Would that be correct, Matt?
Okay, thank you.
You're welcome.
Does the board have any additional questions?
Not for staff.
Who else would you like to question?
On Matt,
Not yet, sir.
Matt, when in the comment, it says that there's a remnant of limited public use. Can you expand on what that means?
I can manage to bring the map back up. Yeah.
Oh, you gotta share the screen.
Oh, all right.
There you go.
So here's the section we're talking about. And this used to be a continuous road that continued down through here and connected to the other public right-of-way here. So this used to be full continuous connection. This portion was previously vacated. I don't remember what year. I think I mentioned it in my comment. And so now we've got this dead-end remnant that we own half of that doesn't go anywhere.
Thank you.
Can I ask a question on this?
I'm sorry, sir. You'll be allowed during public comment to make a statement. Does the board have any additional questions?
Nope, thank you.
Okay. Does the applicant like to make a presentation? Do we have the applicant? Okay. You're not aware of the applicant being
I've
here?
never met the applicant,
Oh,
so
okay.
I thought that gentleman might be the applicant right there. but-
I thought that too. We could have bet that. I thought you were the applicant.
All
The
right.
applicant's not here.
So now
They did it in my property.
we're going to go to public comment, and we're going to start with anyone who's in favor of the application. Is anybody in the room in favor of the application who would like to speak? Anybody online in favor who would like to offer public comment?
I'm sorry.
Anybody online? Okay, in favor, okay, Mr. Kramer.
I'm not in favor, but I would like to see.
Right now, we're for in favor. So now we'll go to online, anyone neutral. Mr. Kramer, you have a neutral comment?
Yes, I do.
Okay, please proceed.
Brian Kramer, Bonner County resident. I am not opposed or against this, but it leaves a lot of lingering questions as to whether the individual who has the structure that is using that access of Fairview Boulevard will retain access, and as to whether or not the like what happens to the northern portion of the road, and perhaps the representative from Old Town will speak to that at some point, but I don't believe that individuals have had an opportunity to talk yet. I think that's in terms of public interest. I think that individual who has addressed access off of East Valley Street is equally as much a part of the public as the owner of the parcel in question who is submitted this application for the vacation.
Thank you. Do we have anyone in the room who's neutral that would like to offer a comment?
Brian Quayle for the record. And I'm here for two entities. The first one is the City of Old Town. We have no objection to the proposed vacation. In fact, we tried to work with the landowner with acquisition and so forth, but they chose this route. But we don't have any objection to it. I'm also here on behalf of the West Bonner Water and Sewer District, as we have a water line that goes up through there, so we want to exercise that part of state code that allows us to go up through there. We know that there's also a couple of landowners that have some access questions, so I'm going to defer to hearing their testimony before I make myself available to you to answer any more of those type of questions for the district or Old Town. And we also have the mayor and chairman here. Would you like to add anything?
No, just state your name. My name's Lonnie Orr, and Mayor of Old Town, Chairman of the West Bonner Water Sewer District. We do have water and sewer lines that run up that road. Actually, they service the property that's in question as far as being too close to your right-of-way. We would like to maintain that, and we would also like to have an easement, a utility easement, go all the way through Fairview, because there are some platted lots on up the line there that, in this day and age, who knows, but they're probably going to want to develop them, and they're going to want services, and that would be an access to us. As far as your map that showed the red line, that's not accurate. When you actually are there and look at that, it dives over, well, that road that is there, there's nobody really knows where the right-of-ways are. It's never been surveyed. So you don't know. So as far as saying, well, this is where it is, nobody really knows where that's at. The paved portion, I do know that when that portion was paved, there was a marker put in the center of that 60 foot. And right now, the city has actually paved more of that than what shows there. And when you get up around the corner, nobody knows where that goes, where your right-of-way goes. But I do know I've lived there adjacent to that for 75 years, and there's always been an access up there to those properties, and the gentleman here is going to speak to. There's been, one gentleman had a business up there, a roofing business, and they used that access for the truck to get the roofing up there for him. There's been other people up there that have taken camp trailers up there and different things to park in their backyard. So it has been used by the public, the roadway that's there now. And nobody really knows without a lot of surveying exactly where the city's portion ends and the county's portion begins. So, thank you.
Can I ask Mayor a question though? Because I think I'm hearing you say that you're not in support of it being vacated though. Am I wrong? Am I the only one that felt like that's really what you were saying?
Have we ever had a truly neutral comment?
No, and I want to be clear, it sounded like you don't want it vacated.
The reason if I sounded that way, the reason for that was because on the behalf of the Water and Sewer District, I don't know whether you've seen that ground, but other than this little roadway that's, I was gonna say about 16, 18 feet wide, it's either steep on this side or drops off on that side.
And you
So
want
if we
the
had to-
option-
If we had to run a water and sewer line up there, that's the path we would have to take.
And so you don't want the road vacated for that portion?
I
Okay.
guess if I had to say one way or the other, I'd be happy. Yes, I'd like to keep it the way it is.
Okay, thank you.
Just painted you into a corner, you
In
got
fact, the city was even considering annexing that portion into the city just for that reason.
Okay, gotcha. Does anybody else want to change their neutral comment? Brian? No? Okay, I'm just,
Thank you.
I was listening to what he said.
Yes, and you listen to what I say. So
So-
I have the same question when I was sitting
So-
back there.
So are you switching from neutral?
No, I'm not switching from neutral. What Lonnie is referring to is that we want to make sure that we're able to run our utilities up there.
There's still an
And
easement.
now and in the future, because there's all these old platted lots that back up against it, and we want to be able to serve those. So that's a utility easement, and that's what so if it's either vacated or not vacated, I think that's where Lonnie was going with some of his comments. In representing the district, is saying we just need the easement up through there. You've got a bit of a problem with, if there's an access easement, then we've got the same setback issue with the landowner because the county requires setbacks from access easements.
So you want us to preserve the road for future access?
He would like to preserve the utility district.
Yes, for-
Let people,
well,
so yeah, we don't object to
Yes.
the landowner's placement of his mobile home.
Exactly. The simple answer to that would have been to give him a variance on his setback, and none of this would never happen.
Because
Actually, this porch
we're here for the road
we need to
vacation.
stay
We're not here
focused
for
on
all of
the-
the other stuff. And so the question that we are being asked is to vacate or not to vacate. And so you're representing two things. So he already conceded he doesn't want it. You're coming as, no, well, I'm not saying change, I'm saying you gotta pick a side. So Old Town doesn't care. But the water aspect of, because you stood up for two
Right.
different.
Two
so but-
different entities.
And now your chair's right there, so what is it? So, but you do care for that, but not for Old Town?
Correct.
Do you have utilities going all the way through there currently?
No.
You don't? Okay.
So you split, so you shifted from neutral on the water to no, but you're neutral for Old Town.
Neutral for Old Town, neutral, the reason why I said neutral for
You're about
the
to change it to
district
not neutral.
was because I just want to take advantage of the Idaho code that preserves the easements for us.
Right.
Yeah,
Okay?
gotcha. Understood.
So if you give me the choice of either yes or no on vacation, that's a little different, so.
Thank you.
Okay,
Thank you.
thank you.
Do we have anyone else in the room who's neutral that would like to make a public comment?
I would like it to be, do you have anyone that is neutral to comment?
All right, now, do we have anyone online who's opposed that would like to make public comment? All right, seeing none, do we have anyone in the room who's opposed that would like to make public comment? Please step up to the microphone and state your name and residency.
My name is Clifford Hill. I live on 309 East Valley Street. That road runs up to ADU that had permits pulled for it. I also want to point out to you guys that the information isn't correct. There's actually two. From this map and show you at kind of point. Right at the curve right there where it kind of looks up there, the house where it looks like its barn go up a little bit, about an inch right there, that barn, there is also a road that drives down into that, and that is this gentleman's property here. He was also affected by this. Okay, so, and then it dead ends at my property. I currently use that road to bring firewood to my house, access to ADU, a bunch of stuff. Right now, if you took a picture of it, I was maintaining the road a couple years ago. You guys probably heard of it. When I did kind of brush it and make it nice, a guy in the neighborhood who had mental health issues ran down a girl, a little boy, and a grandma and killed little Scarlett. They were the last owners of this house. So now I drive over the weeds. They're about this tall, and I was just up there the other day in my truck, I drive right over them. You know what I mean? I want to make it clear, which the guy didn't get convicted of like running them down because they said that the road looked like an off-road that you would want to go 60 miles an hour. He flipped his car on that little road. He was going that fast. So now I do let it go kind of bad. Along with that is actually the only place that my property touches the right of way. I have a driveway out front that cuts through my neighbor's property, but again, being Old Town, it was all shake of a hand. I'm not sure how the laws work there. After so many years of using it, maybe I could beat it in court, but I don't know how that works. But technically, that's the only place that a right of way does touch my property. Bringing that forward with this water district, my water line currently goes through 3 different properties without the water company having easement. I have fell out of escrow already about a year and a half, 2 years ago because of that water line. They are currently working on getting an easement for it. But if anything was to happen, that is the natural path to bring water up to my house. If for whatever reason they can't get easement, that water line busts, that's where the water's coming. So I am fully in favor of keeping it how it is. I want to keep my access. I want to keep a path to bring utilities to my house if needed. And for whatever would happen with that road, which I don't know the laws on it, I still have that access and I won't end up with a landlocked situation. That's pretty much what I got. Any questions from me?
Was your driveway, was it legally done, or is it, so if Road and Bridge were going through, would they identify that as your driveway based on kind of the drive? Do you know that answer?
Well,
or is it just where you
when that girl
go
got ran over and my mother-in-law was at the house and she was the one that called the cops, they couldn't find my house, if that makes any difference. But at the same time, if you go up my driveway, it's a definite road at this point because I plowed everything. I just rocked it. So, I mean, you can definitely.
You can see it, but
it's definitely there, but it does cut through the neighbor to the east of me. It cuts through his property, so I'm not sure how that works, but.
So is your parcel one that has access on East Valley Street?
Yes.
And then you have the gravel on the south side off of.
Yeah, so what you're looking at East Valley Street, that it shows that white line runs to his house, and then there's right where it curves right there, the first curve off the highway, it actually comes up and runs through the corner of that property and to my house, to the garage, which isn't highlighted as the actual road.
So your physical address is East Valley Street, but you don't have legal access?
Well, I'm not.
You don't have a deeded access?
I don't know how that works.
Okay.
I mean, based on how the water line was put in, everything over there was a shake of a hand back then, so.
Gotcha.
You know, that was put in, even the water line was put in before West Bonner County Water District was a thing, so I don't know how all that works.
Thank you.
before you go, can you give him the microphone just so he doesn't have to get up? Because he already said he wanted to comment.
Oh, yeah.
That's a good idea.
Get him, Jerry.
Please state your name for the record.
Jerry May, I'm the owner of the property in question, 303 East Valley Street.
What's your comment for us, sir?
Well, first of all, your comment of where the problem is that your drawing is wrong. I've got a dedicated road that comes up out of out of the housing situation here, up to the white line where what is it?
East Valley Street?
No, it's. What? Caribbean Street. Yeah, where it comes up out of there. I've got a definite line that comes through there, and it's not showing up on your map here. Do you have a better, can you get a larger picture of this, or?
Sir, are you referring to that you have two parcels next to one another?
I've got three.
Okay, it does, the county map does show multiple parcels at your location.
It says I'm still screen sharing with this one.
So this parcel, this narrow parcel and this larger parcel, are those yours, sir?
I'm right on the curve there.
Yep. Okay.
And in fact, just about where your arrow is right now, if you could push the arrow the other direction. Yeah, over there.
I think he's referring to that, yeah, that narrow strip.
Yeah.
And that could be platted as an alleyway. That's all platted there.
Through the city of,
Well, back in 1908.
gotcha.
The town of Cedar Park. Yeah. Okay.
Right. It appears to me that East Valley Street South, this is Old Town's jurisdiction as well, probably dedicated to the public as part of that plat. So all of these parcels here have frontage on that public right-of-way that's under the jurisdiction of Old Town. Whether or not the physical road is built in the correct spot in that right-of-way, that I couldn't say.
Yeah, well, I just needed to know that that was an accurate map. So I don't see I have any problem in letting anyone come through the property there, and that would be fine with me. Just a question, I don't want them to change anything.
Okay. Do you have any additional comments, sir?
Nothing I can think of.
All right, thank you. Do we have anyone else in the room who's opposed that would like to make a comment?
I'd like to change it. Just for some clarification.
Really, Brian, this is.
Brian Quayle for the record. If I could describe actually Old Town's boundary doesn't include what was just referenced.
Here, we can pull that up.
Yeah, and not to be argumentative, just so that we get everything clear for the board, okay?
And you look at me like I'm being.
I just looked in that direction.
Just ask you to pick a side.
He didn't point at you earlier.
I guess.
All right, give me a second.
Admin boundaries.
Yeah, admin.
Thank you. That's what I was looking for.
There you go. So we come on over, and this little slim piece is actually the remnants from a vacation, and the small piece on this side of it, and the reason why it's in Old Town is because that's where some of we needed to retain for utilities and so forth to go down to all these platted lots that's within there. So we don't have any jurisdiction there. The Water and Sewer District provides utilities up there, but the city of Old Town's jurisdiction on road stops there.
Probably a case of our map just not having the ownership of that street labeled correctly. It's probably a privately maintained Bonner County owned road then, if that's the case.
Yeah, I don't believe that there's ever been county maintenance on Valley Street, on that side of the highway. It's beyond memory when it happened, I believe.
All right. Do we have any additional public comment in opposition to the application?
If you keep waiting, they're gonna keep flip-flopping, so.
Okay, with that, we're going to close public comment. We will go into rebuttal by the applicant, but since the applicant's not here, we'll close rebuttal.
So, Commissioner, if I may,
Yes, sir.
for not staff rebuttal necessarily, just information since the applicant didn't show up and this wasn't brought up. The reason for this vacation is because this structure here was placed in the right-of-way. And so there's an existing building violation associated with that. And that's the reason for the vacation request.
Yeah, I saw that in the application. Thank
Okay.
you. Thank you for clarifying
Yep.
that.
Can I ask staff, since you commented on that? Because I kind of hear mayor's comment on this one. To get there, they don't need they're just trying to make themselves compliant. And so are there other avenues for compliance with what has happened to include maybe a variance or something other than a road vacation?
So a variance, no, because they're encroaching on somebody else's property. In this case, it would be the county's property. So you can't ask for a variance to be over somebody's property line. However, they could have requested a portion of the vacation just to include this piece of the mobile home as a possibility. I think it's noteworthy to say that he owns all this property here, the applicant does. It continues. It's just not where this structure is. This is all his. But however, not being able to meet setbacks, he could apply for a vacation for just this portion of, and then get a variance to the setback and requested variance setback of 0. So there's a couple different options available.
Is there an option where it's just recognized as it's done incorrectly? And in part, and when I read this one, it kind of was thinking about, well, does that mean you just put your property on, build something over, and then you kind of get more property if we say, well, I built my house there, so just shift your line because my house is already there. And I know that that's not what probably happened here, but that was one of the things I thought of when I looked at that. Well, what other option, if it's just a building, they built in the wrong spot, and it's the county spot, not a private, instead of vacating the road, is there just an option that the county just says, okay, we're recognizing that? Because in part, when I hear Old Town and we go kind of back and forth, is we don't really know where our development's going to go in that area. Is this the right answer just to fix the building location permit issue? That's my
I guess
question.
if the applicant would have obtained a building location permit in the first place, he would have had the information
Right.
to possibly meet the setback. He chose not to, which ended up in a violation encroaching onto the county property. So another avenue is move the mobile home to meet setbacks, or at least back to 0 in hopes that he could get a variance for a 0 line setback. I guess that would be 2 other options for this property owner.
Okay. Thank you for explaining
Yep,
that.
you're welcome.
All right, so we're into board deliberation.
For me, I don't like this particular file we want to strive for compliance, and I might be a rule stickler, but it requires us to go and ask planning before we do things, and then we would have avoided this situation. And in a way, this is a little bit of compelling the county to vacate county property because we didn't follow a process. And that I don't like about this particular file. And if there's a different avenue by which we address what has happened that doesn't negatively impact the current or future plan, I have a hard time in this case saying that there are, even if there was nobody, but there are people that are in opposition to it, and the reason we would be granting it is solely because they didn't follow we don't have that many rules. We do have building location permit. And not following that, and then you just get a vacation when other people don't want it, that's a hard one just to do for that reason. And then when I hear, like, Old Town is growing, and there's plans that were not fully done, kind of, I have a hard time choosing just based on that reason to vacate a road. Even though I recognize Road and Bridges' Porsche comment about that, how this came to be is someone didn't follow the process. So for me, when I look through, is this in the interest of the public? This comes back to that one, barring some things not being clear because of how old this is. This is solely to benefit one person who did something incorrect. So I could never answer, this is done in the interest of the public. There's no way for me to achieve that answer because it isn't for the public. This is because one person built without getting a building location permit and being advised of how to do a setback. So for me, I couldn't support vacating a road. And the argument that when I read from Road and Bridge, it really isn't a should, it's just, it's not an issue if you did, because there is a little bit of some road that was already vacated, there is public access, but the spirit of road vacation, when we talk about the county, this is not done for the public best interest, this is done because it's hard not to say I'd be rewarding somebody for building without a building location permit. That's what I'm being asked to do, and for me, I don't like that aspect of this, and I don't see the benefit to the public as a whole. I actually could see a potential problem if you set a precedence by which you would be really giving somebody extra property for not following it, and I can't, as a commissioner, say that's an okay way to do something. So that's my concern on this one.
Commissioner Ford?
For rule stickler, would that include speed limits?
Are there any on this road?
Is that the hearing that we're in right now?
That stuck with me. I don't know why. I'm sorry.
Do you need a recess?
I find it amusing the two of you are having this conversation.
I'm using that rule stick. I can't come on time to hear this book in my birthday.
Okay.
So on the topic before us.
This is not in the best interest of the public, as was stated by the officials from Old Town and the Water and Sewer District. If we do vacate it, it does allow for existing, kind of the same thing as the last one, right? It does allow for the existing utilities. But what was stated earlier was that there are future utilities that may be going in there that may not be covered or allowed if this is vacated, which is going to affect more people than just the one person that is wanting it to be vacated because they did something improperly. So that being said, I don't see how I can't consider this in the best interest of the public.
I agree with both of you. I don't want to reward inappropriate behavior, like granting land to solve a problem that shouldn't have been created in the first place. I want to acknowledge the fact that we have adjacent property owners here that have come and offered comment to indicate that they currently have legal public access to their parcels using this right of way. And so if we were to abandon that, we're reducing that access that already exists that members of the public can take advantage of. And so I don't think it'd be appropriate to do that either. I can see where there's not a benefit to the county with creating a through road in the future because of prior abandonments and things that have happened. But I think we just have to respect the existing property owners that already have a legal right to access that we shouldn't take away from them, and in doing so reward someone who did not follow the county's code with the placement of a structure. So I'm ending in the same position I think the two of you are.
I think we'd be harming more than we're helping.
I would agree. So it sounds to me like we've all concluded that we cannot find compliance with Idaho Code 40-2036. Saying that retaining the highway or public right-of-way for use by the public is not in the public interest. Because I've heard us say it is in the public's interest, whether it's for utilities or whether it's for access to other adjoining parcel owners, that we'd be denying them that right if we were to abandon this county-owned right-of-way.
I agree.
I concur.
If we look at the findings of fact Do any of the commissioners take exception to any of those findings?
The only one I couldn't tell based on a comment made was based on materials submitted in the application, real property adjoining the area to be vacated will not be left without access to an established highway or public right-of-way. Based on the comment, I couldn't tell that one. And we have this down in that area, Southwest Bonner County, a lot where people put driveways in and they're not actually legal driveways. And so that one I couldn't be confident on. So that was my only one where I had a question about that. Because I think there's a potential that someone's property could actually be technically losing legal access with that vacation. But I wasn't sure.
I agree based on the questions we asked. What I heard was that it could not be confirmed if legal access exists. There may be physical access, but we don't know if it's legal access.
Yeah.
Because of the age of the plat and some of the questions that have been raised about whether or not lines have been followed and things of that nature over the past 115 plus years. So I would agree that if we were to simply modify the finding of fact to say that real property adjoining the area to be vacated is not known to be left without access, it's a point that we don't have absolute clarity on.
Commissioner Corn?
I'm fine with that.
So with that modification to the findings of fact in our prior deliberation with regard to state statute, probably move into a motion if the commissioner is interested in doing so.
I move to deny this petition file VS0003-25 to vacate a portion of the Fairview Boulevard as identified in Appendix C of the staff report based upon the following conclusions. Conclusion 1, the proposal was reviewed for compliance with the vacation criterion standards set forth at Idaho Code 40-203. Conclusion 2, Bonner County has received objections to the petition or application to vacate the described area. Conclusion 3, the abandonment of the public right-of-way is not in the public best interest. Conclusion 4, the landowner or landowners abutting said right-of-way may or may not have access to their property from some other public street, public right-of-way, or private road. Conclusion 5, granting this petition for vacation of public right-of-way, real property adjoining the subject highway or public right-of-way may or may not be left without access to an established highway or public right-of-way. The decision is based upon the evidence submitted up to the time of the staff report was prepared and testimony received at the hearing. I further move to amend the findings of fact, that bullet point number 2 to 3, to state that based on materials submitted in the application, real property adjoining the area to be vacated may or may not be left without access to an established highway or public right-of-way. This action does not result in a taking of private property. The action that could be taken, if any, to obtain the vacation is to file a new petition with the planning department and meet the standards required by Idaho Code or pursue such remedies as may be applicable at Idaho Code Title 40, Chapter 2.
I'll second the motion.
Or deliberation? I will ask, Commissioner, I think you did a good job of adjusting the language to amend the findings of fact. I think in doing so, we may have missed the part that talks about directing planning staff to draft written findings and conclusions of law to reflect this motion and transmit to all interested parties. Did I may have just missed that.
No, I didn't say that.
Okay.
So we're just going to include that and say Asia just said that.
So the motion is so amended? Any further deliberation? Hearing none, roll call vote.
Commissioner Donkey?
Yes.
Commissioner Williams?
Yes.
Commissioner Corn?
Yes.
Motion carries. In doing so, VS 0003-25 has been denied. It is 4:31 PM, and this hearing is adjourned. Thank you, everyone.
Wanted to share with you that